Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Some time ago, I discussed the case of a Saskatchewan RCMP officer who was charged with unauthorized possession of a restricted firearm, and the circumstances there were that he'd acquired this firearm lawfully, and then he let his firearms license lapse. Now, in the course of looking through paperwork, they discovered, hey, we've got no record of him getting rid of this firearm. And it turned out he still had it, notwithstanding the fact that he didn't have a license. So they charged him, and since then he's now pled guilty. So we now have an update to this. Now let's have a look at what happened, and I'm going to talk about what happened, the law around that, and some thoughts about this. So we see Saskatchewan RCMP officer receives absolute discharge after failing to renew license of personal gun. Now I'm going to be including a link to this article. It's really short, but it just contains a few key details. The first is that he's pled guilty and he's received an absolute discharge. He's also ordered to pay a surcharge fine of $500 at his sentencing hearing last month. So I'm going to talk a little bit about both of those elements and what this means. Now, some people have said, hey, how can this guy be charged with possession of a firearm, or an unauthorized possession of a firearm when he's a police officer? Don't they have exceptions? And in fact, there are exceptions for police officers, but they apply for while they're on duty and for the purposes of duty. Now, that doesn't necessarily only apply to their own firearms, because, for instance, if a police officer enters a house, let's say they have entered on the basis of a search warrant because this is a house where there's, drugs, drug dealing going on and so forth. And in the course of that, they find a firearm. Well, the officer is not going to be subject to charges if he takes possession of that firearm in order to effect his duties, bring that back to the station, log it into evidence, that kind of thing. Now, he would be charged if he decided to take possession of that firearm for non-duty purposes. He goes, hey, this is cool, throws it in his trunk and takes it home. Now he's in trouble. So that's an important distinction. Because this is a personal firearm, he's not protected by those sections, and he's got to follow the same rules as anyone else. So the first thing here is that he got an absolute discharge. Let's talk about what that means. And that is in the criminal code here, section 730, absolute and conditional discharges. Where an accused, other than an organization, pleads guilty to or is found guilty of an offense other than an offense for which a minimum punishment is prescribed by law, or an offense punishable by imprisonment for 14 years or for life, the court before which the accused appears may, if it considers it to be in the best interest of the accused and not contrary to the public interest, instead of convicting the accused, by order direct that the accused be discharged absolutely or on the conditions prescribed in a probation order made under section 731 sub 2, which is the section for probation orders. Now there's a lot here. That's a very dense paragraph. Let's break this up a little bit so that we understand it. Pleads guilty to or is found guilty of an offense. So you can get an absolute or a conditional discharge whether or not you plead guilty or if you're convicted at a trial, or found guilty rather at a trial, because an absolute discharge or a conditional discharge is instead of conviction. So you're still more likely to get a discharge if you plead guilty. That's just because typically sentencing is lesser when people plead guilty. The courts take that as an admission of responsibility, but the criminal code doesn't say that it's precluded if you don't plead guilty. Now, other than an offense for which a minimum punishment is prescribed by law, or an offense punishment by imprisonment for 14 years or for life. So if there's a mandatory minimum punishment, you can't get a discharge. And for certain very serious offenses, murder, not available. So the court before which the accused appears may, if it considers it to be in the best interest of the accused. So that's the first bit, best interest of the accused. Keeping in mind that these are some of the lowest punishments available, and in fact that they spare the accused from getting a criminal record, and I'll talk a little bit more about that. It's almost always in the best interest of the accused. I find it very difficult to imagine circumstances where it might not be. And the only places that really come to mind is a circumstance where the court is considering either a fine, which would come with a criminal record, but no probation term, versus a conditional discharge, which would have a probation term, and maybe you've got somebody who just can't follow a probation term. So there it might not be in their best interests. And not contrary to the public interest. Now, this is interesting phrasing because sometimes people say, oh, it has to be in the public interest. That's an incorrect phrasing. That's wrong. It's not contrary. What that ends up meaning, the difference between that language is that we give the gray area to the accused. It has to be not contrary, but you can have this thing where it might not be in the public interest that the accused get a discharge, but it's still in that gray area where it's like, well, it's not against the public interest. It's kind of in that mushy middle. So that still makes it possible. Now, just because it's available doesn't mean you're going to get one necessarily. That's up to the court. So instead of convicting the accused, by order discharge that the accused be discharged absolutely or on the conditions prescribed. So instead of convicting the accused, you don't get a criminal record if you get a discharge unless you screw up in certain ways on a conditional discharge. And we'll talk about that. Now, absolute discharge means that there's no probation order that attaches to it. There's no punishment. It's just we found you guilty, and the punishment is off you go. Hopefully don't do it again. Because you're not going to face any punishment at all. You don't get a criminal record, so it is the best possible outcome. There is no better outcome in terms of a finding of guilt. Like once a finding of guilt has happened, there is no better outcome than an absolute discharge. Now, a conditional discharge has a set of probation terms, and if you breach those terms, one of the nasty little bits here is that where you're bound by the conditions of a probation order made at the time when the offender was directed to be discharged under this section, and you're convicted of an offense, including an offense under section 733.1, which is breaches of probation order. So if you don't follow your conditions on the probation order, the court that made the probation order may, in addition to or in lieu of exercising its authority under section 732.5, at any time when it may take action under that subsection, revoke the discharge, convict the offender of the offense to which the discharge relates, and impose any sentence that could have been imposed if the offender had been convicted at the time of the discharge, and no appeal lies from a conviction order under this subsection where an appeal was taken from the order directing that the offender be discharged. So, a whole lot to that, but basically, if you breach your conditions, it is available to the court on a conditional discharge to say, actually, we're going to undo that conditional discharge. You're going to get a record, and we're going to actually sentence you anew. So not only did you have that probation term, but now we're going to impose some different other sentence. So all of this is, is interesting, but at the same time, what we get out of this is that the accused, or that the officer here was found guilty and faces no punishment. Now you might be saying, how's he facing no punishment? I heard the words $500 fine. How's he getting a $500 fine if he's facing no punishment? Because normally, if you get a fine in Canadian law, that comes with a criminal record, and that would be a big problem for this officer, right? This is a big consideration that's going on here, is that they don't want to give this cop a criminal record. So let's have a look at the relevant section for that, because that's kind of an interesting aspect here. So victim surcharge. An offender who's convicted or discharged under section 730, so it is available on an absolute discharge, of an offense under this act, the Controlled Drugs and Substances Act, or the Cannabis Act, shall, which means must, pay a victim surcharge for each offense, in addition to any other punishment imposed on the offender. Now, there is some wiggle room on that shall. Amount of surcharge. Amount of the victim surcharge in respect of an offense is 30% of any fine that is imposed on the offender for the offense. We don't have a fine here, so that doesn't apply. Or if no fine is imposed, $100 in the case of an offense punishable by summary conviction, and $200 in the case of an offense punishable by indictment. You might be saying, wait a minute, how do we get to $500? He pled guilty to one count, and that news article doesn't say if it was summary conviction or by indictment, although I'm going to bet it was summary. So how do we get to the 500 amount? Well, there is a provision. The court may order an offender to pay a victim surcharge in an amount exceeding that set out in subsection 2 if the court considers it appropriate in the circumstances and is satisfied that the offender is able to pay the higher amount. So they said it's appropriate in the circumstances that this officer pay $500 instead of, $100 or $200. Why would the court do that? Well, you can see that this might be a bit of creative sentencing in the sense that the court is saying, listen, we don't want to give you a record, but we do want to make you pay $500 here. So we're going to do that by the victim fine surcharge rather than by imposing a fine, because if they imposed a fine, then the record would happen. So this is a bit of a clever workaround. Now you might be saying, oh, well, this is something that only happens for police officers. And not really. I have seen this happen for non-police officers. And in fact, I would say it's not super uncommon. It's not like something that happens all the time, but this is not unheard of at all. Now, this is a light sentence, and I would say that I'm not sure that a non-officer would have gotten this sentence. I've seen some people saying, oh, well, they would have thrown the book at them if he wasn't a cop. Well, not really. I mean, I think that maybe other people might have gotten a fine or probation, which both would have come with a criminal record. They might have gotten a conditional discharge, or they might have gotten the absolute discharge. And the other thing is that in some cases, I think that the Crown might have proceeded by by what I think would have been the actual better way to proceed with this, is just to say, listen, we got the gun. We're going to withdraw the charges because we don't think there's any public interest. I've seen that happen in very similar circumstances where somebody had a firearm and they forgot to renew their license. So some people have said this is, a travesty, that this officer should have been punished more harshly. I'm kind of of a mixed view on this one, because on one hand, I think that we should hold police to a higher standard, not a lower standard. But I wouldn't be upset with this sentence for anybody. I think that this is an appropriate sentence for anybody in this circumstance, for the court to say, listen, yeah, you screwed up, but you weren't robbing banks with this. You weren't, pointing this at your neighbor. You weren't, selling this to buy drugs. You weren't any of those things, right? You weren't doing anything other than just not getting rid of it when maybe, the law said you should. So I kind of feel that this should be the standard, not an exception. And as I've said, I've actually seen lighter punishments imposed on some other people in similar circumstances, so I'm not super upset. The one thing that I will note is that I have also seen other people in similar circumstances end up with a firearm prohibition at the end of this, where they're banned from having guns. And that doesn't appear to have been imposed on this particular officer. I would have been surprised if it was, because the consequences of imposing a firearm prohibition on a serving police officer are pretty serious for that officer. I mean, if you're a police officer and they ban you from having guns, well, you're not a police officer anymore. You can't do the job. So, yeah, I'm not upset that the officer got this sentence. I'm more annoyed that there are some other people who haven't gotten this sentence in similar circumstances. That's, I guess, the thing here. But calling out, I think that this is the wrong file for people to say, hey, listen, the cops are getting a break, because this should be the ordinary sentence. This is not like one of those circumstances where I see a police officer who's being sentenced and go, nobody else would get that sentence. That's not the case here. So I'm kind of okay with this one. I'm kind of fine with this one, as much as, you may see me criticizing policing, and especially criticizing sometimes the sentences and the oversight and the punishment regimes as they apply to police. Not here. I'm good with this one. We're good. And assuming that this is the only thing that this officer has done wrong, I have no beef with this officer continuing to be a police officer. I think that's a good thing here. Like, there's no reason for this officer to be kicked off the force or anything like that if this is all that's going on. Anyway, a lot of people wanted my comments on this one. I don't know if they're going to be satisfying because this isn't really a rage and fire and brimstone kind of video. This is how things should be. Anyway, thank you for watching. I hope you found this to be interesting or educational. If you have, please like this video, share it with your friends, subscribe to see more content. You can also check me out on Locals. If you're subscribed there, I post videos without the advertising that YouTube throws in. I also want to thank my Patreon supporters, and at the $50 level, that's Jonathan Wheeler, Jason Elliott, Canada's National Firearms Association, Slightly Left of Center, Good-Natured Hypothetical Firearms Association, Mike, Kyle Martin, Jean-Guy Toussaint, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Raymond L. McKinnon, Matt Ward, Mark Whittington, Jaden Babin Luxor, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Del Salt. Thank you as well to the $10 supporters who will be in the crawl immediately following, as well as all of you. Thank you once again for watching, and I hope this has armed you with knowledge.